From unit 3, this is the last topic that we are having, which is relating to judgment. Okay, now there will be FIR might be filed, there would be investigation, there might be preliminary report would be submitted, some inquiry would be done, then trial would begin. Right? Once the trial ends, judgment would be pronounced. Judgment is nothing but what is the difference between order and judgment?
Order and judgment.
Yeah, order of court and judgment. Order and judgment.
Order and judgment both given by the judge. Judgment is the end of the process, whole process. And acquittance or punishment will be specifically written in judgment. Order, I don't know, madam.
Okay. So order and judgment, right, both are given by the judge who is deciding the matter. Order is nothing but in between also something may happen. Right? Well, take for example, there is like a criminal or civil also, whatever it is, okay? Criminal case that continues for might be 5 years. Okay, that is continuing for 5 years. So after 5 years, when finally the case ends, that time only judgment would come. Judgment as in finally court has decided. Final verdict court has given that this is what we have decided. We are concluding the case. That is judgment. In between also, during this 5 years time, right, there will be multiple hearings that will take place. In every hearing or in whatever hearing, right, court might say something that is nothing but order. Like take for example, in the second hearing. Okay, in the second hearing of the case, the defendant says that I have some documents. Okay, I have some documents with me that will prove that I am not guilty. But I need some time to submit these documents because I am living in Bangalore and these documents are in Delhi. So what I need is I need some time so that I can travel to Delhi, I can collect those documents, come back and submit it. So one person, take for example, is asking for 1 month's time or might be 15 days time. Okay, in such case, what court would do, right? In this second hearing, court will end the matter there. Court will say that, okay, fine, he is right. He needs some time. We are giving him 1 month time. So today we are ending the matter. He needs to produce those documents after 1 month. So that is nothing but an order. So something court has said, but finally it has not decided. Right? Might be it has given some time to the person, it has allowed something, it has put some restrictions. Whatever court is deciding in between, those will be orders.
So in the order case, court want to help the defendant.
Not like help the defendant, whatever it might be, right? In every hearing, court would say something, right? What happened in the hearing, that would be written. That is nothing but order. Okay, if you see any kind of court cases, right, you would see their orders also would be attached. So yes, these are nothing but it. Take for example, sometimes it may happen that one person is charged of some offenses and police officer says you cannot leave this particular city or country. You cannot go outside because you are released on bail. Okay, but for the person, it's very important to go somewhere, might be abroad or some other city. There he can ask permission of court, and if court allows, that is also nothing but order. Right? Different kind of matters, orders could come. So in between, whatever court is deciding, that is order. Finally, what court is deciding, that is judgment.
Yes, yes.
Yes, so there would be multiple orders, and there would be
such orders also form part of the judgment.
Finally, judgment would be like summary of what entire thing happened, but might be that court gave 1 month's time for the person to travel to Delhi. Those things would not be written in the judgment. But yeah, if it is something important, that will be written in the judgment.
Yes.
So there will be multiple orders in one case and only one judgment you would see. Hey, before we continue, I wanted to inform you about my live mentorship program for LLB students or law aspirants. Law subjects and law topics need detailed clarity. We get that with the help of cases, examples, and detailed explanation. It's definitely not possible to include everything in these short videos. If you find my videos easy to understand and you are looking for some professional help in preparing for your examination, you can join my live mentorship program. Here you will be getting exam tips, answer writing skills, detailed notes that you can refer for your examination, cases, examples, and in a very easy way topics will be explained. I have live classes going on for a lot of subjects as of now. To know more about it, you can drop me a message on this WhatsApp number. I'm also helping a lot of students in writing their assignments. If you need any such help or for any queries, any suggestions, you can drop me a message on this WhatsApp number. And now let's continue with our video. Okay, so what is judgment? Judgment under the eye of law is nothing but decision which is given by the court of law on a suit which comes up to it. So whatever finally court decides, that is nothing but judgment. Okay, so judgment deals with matters relating to judgment and its delivery. What finally court has delivered. Is it court found the person guilty? Is it court acquitted the person? Is it that court gave him benefit of doubt? What is it? That would be mentioned. If court has found him guilty, what is the punishment? Why is that punishment given? Under what law punishment is given? Everything will be clearly mentioned. And what if we do not follow it? Everything will be there. A judgment can be considered to be nothing but like a final order, because there will be multiple orders. Finally, when it is decided, we don't call it as order, we call it as a judgment. So there was one case where Supreme Court defined what judgment is. It is the final decision of the court intimated to the parties and to the world at large by formal pronouncement or delivery in open court. What is open court?
Open court.
Open court basically means that court is open for anyone to enter and see the proceeding. Okay, take for example, you want to enter a criminal court and see how the proceeding is going on. You need not be a party to the case, or you need not be someone related. Even a person from the public also can enter and sit there and see what is happening. Okay, many times you would see some lawyers, some other parties are also sitting because next is their case. So everyone is allowed to sit in that same room. There is no restriction. It is nothing.
Normally, trials takes place only in open court.
Yeah, open court only. It is open court so that it ensures that people are, like they are also aware that okay, everyone is saying we need to do justice.
There are only other types of court is closed courts, isn't it? Closed court and open court.
It is called it is called as camera trial, which is like for arbitration and all those matters. Like take for example, divorce, custody, those matters, people are not comfortable discussing it in open, right? What happened and all. So those matters would be like camera trial, as in only related parties can be there. Any random stranger cannot enter and hear what happened. So those are like sensitive matters where parties would not be very comfortable discussing it in open forum.
Yes.
Yeah, so this is what the judgment is. So under criminal procedure code specifies pronouncement of judgment. In every trial, it would be done in open court where the judgment would be given, and finally when the matter is decided, the judge, whoever is dealing with the matter, he would give the decision. If the accused related to the judgment is under custody, then such a person should be brought to the court when judgment is pronounced. So accused also would be brought before the court, judgment would be read before the person that this is what the judgment we are giving, and also copies of the judgment would be given to the parties so that they can have a copy of it. If they want to proceed with appeal or other provisions, they can do that. Absence of pleader during pronouncement of judgment shall not be deemed to be enough reason for causing any delay in the judgment, because mostly it happens that court has already decided, like in the last hearing, court has already decided that this is what we are going to do. but pronouncing judgment might take another day. They might say that, okay, we are framing the judgment, we are writing it and everything, so they might take another time. Okay, like in the before hearing only, it's almost clear that this is what judgment court is going to give, but formally writing it and pronouncing, that might take a while. So even if the advocate or the pleader is not present, that would not be a reason that, okay, today we cannot pronounce the judgment because pleader is not there. Judgment would be
Yes.
anyways pronounced because already they got an idea itself, right?
Yes.
So this is what it is. Like take for example that Aryan Khan's, Shah Rukh Khan's son, when he was given bail, right? Court said that, okay, we have decided that we are releasing him on bail, but what conditions we should be putting in the bail bond, that we need to decide. We need to frame our judgment. So we will take another 2 days time, and after that we will give. Right? So before that only pleaders knew. So if they are not present, means that would not be a reason for any delay. Now, language, what is used in the judgment, right? The judgment should be in official language of the respective court. Take, for example, if you see Supreme Court, decisions will be in English, judgment would be written in English. If you look at judgments of 25 different high courts, it will be in English. But if you look at decisions of subordinate courts, okay, there are states like Gujarat, UP, their judgments would always be Hindi and Gujarati, their local language. Why? Because in subordinate court, that's like the
State language.
Yeah, state language can be used. So in that specific language, it will be there. Gujarat, everything would be in Gujarati. UP, everything will be in Hindi only, right? Karnataka also mostly I have seen in Kannada. Like that, it will happen. The judgment shall not contain the point or points for determination. The decision shall contain point or points of determination, decision there. It would also mention that these might be the questions which we had to decide. And this is how we have decided. Sometimes you will also see they would give like point number. Question number 1, this is what we have decided. Question number 2, this is what we have decided. So point wise, whatever they have decided, everything would be clearly mentioned. It would also mention what are the sections, what are the provisions under which the person was charged, under what law he is punished, everything would be clearly given. Okay, sometimes it might happen that person is given punishment. Okay, court will also specify that in so and so case, this court had given this kind of a punishment. In this case, this like cases also would be mentioned. That, right? In previous case, this happened, this happened, this happened. So we are coming up with this kind of a decision. That also happens because we follow what is already being decided, right? So these kind of things we see in a judgment. Plus, when we see the judgment given by like a subordinate court, we also see case number is mentioned there. When the offense was committed, like there would be brief fact of the matter also. How the situation happened, what happened, those also will be mentioned. Who filed the complaint, who is accused, what is his father's name, husband's name, residence address would be given. Offense complained of and proved, what were the charges, what is proved, plea of the accused, his examination, final order, date of such order. In all cases of appeal filed. So all these details you would see. First of all, it would start with like a brief fact, court name, party's name, date, everything would be mentioned. And after that, it would also give details on why this decision, what is the reason, all these things we see in a final decision. Have you seen any judgments?
No, I have not seen any judgment full.
You have not seen, is it? Okay.
Because mostly judgments minimum 100, 200, 300, 400 pages.
Yeah, sometimes lesser also we see. I can show you sometime maybe a judgment.
Okay, madam.
Yeah. So additional charge and procedure to follow any alteration. So the court shall have the power to alter or add charges at any, sorry, this one. Yeah. So the court to demand compensation from the accused, and this section tells about power of the court to demand compensation from the accused with regard to losses incurred by the other party to the suit. Such compensation may be for cost of the proceeding, etc. If one person has filed a case and decision came against him, court would say this other person had to incur some cost, right? In order to punish you, this other person had to incur some cost. He had to hire an advocate. He had to take so many printouts. He had to send notices. He had to, like medically verify certain things. For all these things, right? Cost also you need to pay. So those compensations also might be mentioned in the judgment itself. If a person gets arrested due to another person registering a false complaint against such a person with the police, then court shall order such a person who posted the complaint to pay compensation, which shall not exceed 1,000 rupees to the person who is so arrested. Such compensation is required to be paid for the loss of time, money of such person. Unnecessarily, if someone is being arrested, for that also compensation might be paid.
Yes.
Now, when an accused person under section 360 or under provisions of like false complaint, if it was filed, when the offense of the person is supposed to be considered under Children's Act. So what happens is, if unnecessarily one person has suffered, whether it is because FIR was filed, whether it is because he was unnecessarily arrested, or it may be because he was unnecessarily dragged to the court. Whatever might be the reason, court would take into consideration those matters as well, and provisions may be mentioned in the judgment for those as well. So once a judgment is pronounced in an open court, that should be like a final judgment. After judgment is pronounced, they would not make any kind of changes there, unless and until it is a matter of appeal or something, that judgment would be considered as final. But yes, in the judgment itself, they would mention that, okay, you have 90 days time, you have this much time, you can go for an appeal if you want, right? If you are not satisfied, you can go for that as well. Copy of the judgment which is pronounced by the presiding officer of the court shall be given out to the accused, the complainants, and all such persons who are related. If there are multiple plaintiffs, multiple defendants, whoever are the parties, they will be given a copy of the judgment as well, so that they can have it for their reference. And now, mostly because cases we get to see it open, right? It's like available in the public platform, so we get to see the judgment also coming up, like it's open for the public to access as well. Every judgment pronounced by a court should be recorded. In an instance where such judgment is not in the language of the court and accused requires so, then the judgment should be translated into the language of the court and stored accordingly. So judgments are also stored. That is why you would see there is one e-court, like electronic court, where all the details would be updated. Cases pending or not, what order came, what judgment came, everything would be updated as well. In case a judgment is pronounced by a court of sessions or by chief judicial magistrate, then a copy of the judgment shall also be sent to the district magistrate as well. It is only for the record keeping purposes that they should have copies of the judgment, what happened in the case, what decision came, they should have a clear idea on it. For that, they need to keep records of it. Okay, so this is all about judgment. Is this part clear?
Clear, madam.
Do you want to see a judgment?
Yes.
Let me show you.
Throughout the country, all court judgments are public documented nowadays.
Court judgments are public documents, but to access that, you need to know maybe the case number or party's name, some information you should be having. Otherwise, simply you cannot just opened it.
Mhm.
So this is what we call as e-courts. So this is what we call as e-courts. Here you get this case number you should be having, okay, CNR number. Once you have, you can put it here and you can put this captcha.
CIN.
Yeah, CIN number. For every single case, you would get this particular number. So see, when
CIN,
you open, yeah.
CIN stands for?
Case and identification number, I think.
Identification case index.
This would be, I think, case indexing number or something. Actually, for company
Okay,
registration, also same CIN is used. So
okay, okay, madam. Okay.
that is good. Okay, so this is where you get all the details would open, right? Party's name, which case and everything would open. See here, order number you would get. This case is also decided. One order they have uploaded. Sometimes many details would not be uploaded because again, they are, like trying to become this online thing. They are just trying, right? So sometimes all the details you might not find, but yeah, this is what it is. So this is like final order. So this is nothing but judgment. Here,
Judgment.
like they said, right, you would get details of the case, when case was filed, when it was registered. You will get court name also. You would get name of the party who filed the case, who is the other person you would see. See, I said, right, in Gujarat, it would be all Gujarati. This is all Gujarati they have written. But yeah, point-wise they have written, right? They mentioned this in this particular case, like this a decision came. In this case, this kind of a decision came. See, so many references they have given, and finally they would say, this is what we are deciding. Right? So who has given the decision, judge's name would be there. He would sign it also physically, place, everything would be there. This is how a judgment looks.
Yes, madam.
That's all about it. Okay, fine then. So there are 3 topics remaining. We will cover that in tomorrow's class. Okay, 5:30.
Okay, madam. Yes, 5:30.
Yeah. Okay, fine then. Sure. We'll end this here. Yeah.